I think it's time.
I think it's
we
time.
We have an absolute legend.
We have John Quinn from Quinn Emanuel in the
very
Ultradome.
excited
We're very excited to bring him onto the show. And I have here printed out, good to meet you. Welcome to the show. John, welcome to the show. Thank you so much for joining.
Great to meet you.
I have here printed out one of the greatest out-of-home advertisements in the history of California Burbank Airport, I believe is where I saw this one for the first time.
Found that.
It says, Quinn Emanuel trial lawyers, justice may be blind, but she still sees it our way 88.4% of the time. Did you think of this marketing copy? Was this some genius on your team? How did this come about?
It was within our firm.
Okay.
It wasn't some outside PR
That's
firm,
great.
But, you know, we came up with the copy.
Yeah, it's amazing. Talk to me about a little bit of the of the journey. How are you defining the firm now? Has anything changed over your career? I mean, it's not exactly a non-traditional path. You know, you went to law school, built the firm, but what were the key decisions along the way?
Well, I started out at a big firm in New York that's very well known, Cravath, Swaine and Moore.
Oh, yeah.
But, you know, I'm from the West. I grew up in Utah.
Yeah.
Went to college here in L.A. Really liked L.A. I liked New York.
Yeah.
But I decided I wanted to come back to L.A. Came back here, bounced around a little bit. And we started this firm in January of 1986. And we started with 4 lawyers, downtown L.A., not too far from here. And along the way, we decided to focus just on disputes work, litigation work. So most large firms, we're now 1,300 lawyers almost.
There we go.
In 34 locations around the world. Most firms of that size are so-called full-service firms.
Yep.
So they'll have some deal lawyers.
Corporate.
Yeah, they'll have corporate lawyers. They'll have some tax lawyers, trust and estates, and somewhere they'll have some litigators. And we thought, we came to realize that this model of only doing litigation, arbitration, disputes work, government-facing, kind of dealing with legal risks in all its different forms was a very powerful model. And so we decided just to stick with that. We're not going to try to be...
And historically, people would diversify because they wanted the stability of a variety of different businesses, or they wanted to be able to add kind of contract value, effectively like add hours to existing relationships.
You know, so if you have a
Because I'm
client...
sure you would have had pressure over time from people that say, I love working with you, can you do more for me?
You know, I think the thought is you want to be able to service all a client's needs. So a client may want to do some M&A work, they may want to raise some capital, and then they may need tax advice. And then
you're effectively
from time to
cross-selling.
time they'll have a litigation. So the thought is to cover all those. And by the way, that's how our industry is organized. We're one of one.
Yeah.
I mean, there is no firm. I don't know what the next largest litigation-only firm in the world is, but it's probably not more than 50 lawyers, wherever it is.
Yeah.
And we're almost...
So you started in 86. How long did it take you to become the most feared lawyer in the world?
Well, so what you're alluding to is there's a consulting firm, BTI Consulting. We had nothing to do with this. They called us up one day and told us they were doing this survey. That they survey the general counsel at like 350 large corporations around the world. And they asked them, what law firm do you least want to see on the other side in a dispute? And they were publishing a list, and you know, we've always been on that list of the top 4. They call it the fearsome foursome. And a few years ago, we got them to tell us, okay, of the 4, which one actually got the most votes? And they told us, and for 5 years running now, we characterize it as the most feared law firm in the world.
It's good to be feared.
Well, in our business, we don't find clients very often that are looking for shrinking violets to represent them, to stand between them and trouble.
Yeah.
They're looking for lawyers that will cause the other side to think twice.
Yeah.
You know, there's a settlement here, this can go away for this amount, or you see what's behind door number 2.
Yeah.
And so, you know, we think we can get resolutions that other firms can't because of our reputation and our record.
What's the
you
secret
can pay
to
for yourself.
90% win rate? Is it case selection? Walk me through all the decisions that make sure that you're...
No, we don't just select winners.
Yeah.
We don't select just winners.
Yeah.
I mean, we're in for the hard cases,
Yeah.
the tough cases to win. And what's behind that is, frankly, there aren't shortcuts.
Sure.
Doing what we do at the highest level is labor intensive.
Yeah.
And it requires people who are not just smart, but truly dedicated.
What's the hardest case? What's the long shot that you actually wound up winning?
Well, early in my career, I mean, I'd be embarrassed to kind of tell you the facts. It was an employment case, and we were defending a discrimination case where there were two plaintiffs. They were both African American. They were both, over 55 years old, I think, and they were both let go. And there was evidence. The plaintiff had some evidence that the motivation behind they had both been terminated from their jobs, that the motivation, you could argue, that age entered into it, maybe race entered into it, and it was a very, very tough case. And I'm kind of embarrassed to tell you almost these 30 years later, I mean, we won the case.
What about in tech? You've been a part of some of the biggest tech cases. Is that something that took you a while to get up to speed on? Is there anything different about working with a big tech company from any of the other work that you do?
So we noticed 25 plus years ago what was going on up in the Bay Area and in Silicon Valley. And we made a decision that we wanted to be part of that and start doing some intellectual property work, patent litigation work, tech work. So we're there for the conflicts. We're not raising money. We're not doing the M&A work. It's primarily patent litigation. We now have the largest patent litigation practice in the world. But we sent a lawyer up there to start an office. And frankly, it was a little bit difficult to get traction in the beginning because there was then, I think it's diluted somewhat now, kind of a Silicon Valley culture. And people wanted to know how much Valley experience did you have? And we were kind of outsiders. We did recruit some people locally, but it took us a while, frankly, to get some traction.
What's different about Silicon Valley? There's so much about Silicon Valley that is weird around IP. It's like in software, there's a world where if somebody developed a unique user experience, you would have been able to really enforce that. And in the scale of time, if a big platform creates some incredible feature, it's going to get copied by every big company that it's relevant to. How did that kind of evolve? Because I think early on, you maybe would have expected that you could have, if somebody like a Snapchat creates a stories feature, that could have been, there's another world where that could have been IP, but it didn't play out that way.
There is kind of a culture, there's a feeling in many circles, especially among the biggest companies, the hyperscalers and the like, that you should compete based on your business, don't compete on IP. I mean, there is a reluctance.
Which is completely different than like almost every other industry in the world.
Biotech would never say that.
Well, I mean, you don't see the big automobile companies suing each other either. You don't see the big airplane companies. There'll be trade disputes between Airbus and Boeing, but not so much technology disputes.
Interesting.
And there is kind of a feeling, and Elon Musk has been outspoken about this, that anybody can use our inventions. He has said things like that in the past. So you don't see the big players going after each other so much. They will. There are examples. But there's kind of an ethos that you compete on the business, you compete on your offering, and you don't compete with IP lawsuits.
What lessons did you take away from working with Elon? Is he different than other clients? Is there something that you were coaching or advising at various points in time?
Well, we've represented Elon in a number of cases, including cases that have gone to trial here in California. There was that defamation case, the British cave diver, where there was a tweet about whether this was a pedo guy. And the case about wanting to take Tesla private for $420 a share, funding secured. We tried both those cases. I was not on either one of those trial teams. So I have not. We have a team of people that work very, very closely with Elon. So what I know about him and our experience working with him is secondhand. I do know. He values his time. He closely guards how he spends his time. I think it's fair to say that based on what I've heard, that spending time with lawyers, preparing for depositions, and trial at the like is not at the top of his list of things that he likes to do.
Not a priority.
I can imagine.
So
Yeah.
he's a busy guy, and obviously he's got great instincts himself.
Yeah. Well,
What about?
I can tell you just one story.
Yeah.
So in that defamation case, he had tweeted
Yeah.
that I assure you this British
Yeah.
guy is a pedo guy, and he came into Elon, then lived in Los Angeles, sued him for defamation here. We didn't have a lot of time to prepare him for trial, and when the trial started in federal courthouse downtown, the plaintiff called him as their first witness. You can do that. You can call the adverse party, put him on the witness stand, and immediately start cross-examining him. So the jury, the first witness they see is your adversary being cross-examined. And the question to Elon was, when they put him up there, was, this is a defamation case. You're Elon Musk, so the world really cares about what you say. Not a bad question. Like, what's he going to say? I mean,
Yeah, it's hard to
and
deny.
there's kind of a beat, and he says, well, I'm not so sure. I don't know. I've been talking about our need to get away from fossil fuels for so long now, and it just doesn't seem to be happening. I'm not sure people
aren't listening to me at all.
People listen to me at all.
amazing, yeah.
It was like genius.
That's remarkable. Yeah, that's a good argument. That's very funny. I mean, we're tracking like a crazy AI boom, crazy tech boom right now, mostly from the financial markets. We have founders on. I'm sure we have 7 people on today that are raising a lot of money. Is there a boom in tech litigation?
Well,
right
maybe
now?
even before that,
Sure.
talking about kind of the dot-com era, you saw this craziness. We opened the show talking about how people were just valuing eyeballs, right? And there was, aside from that, there was like, these round trip, effective, commercial agreements that ended up getting litigated in the years following after the crash. What kind of stood out from that era? What was just, I guess, what were the takeaways from that era? Did you ever think we would repeat that kind of cycle? Because I'm sure you were in your job even after the crash just got busier and busier.
Yes, whenever there's a crash, as in the financial crisis, for example, 2008, which we were very involved in, that plays out in the courts, of course. There'll be people who've lost a lot of money. There'll be claims of fraud and misrepresentation. In the dot-com boom, there were down rounds. There were class actions of all kinds, securities class actions. So every deal gets scrutinized in retrospect. In AI, where we are, look, I'm not an economist, and I'm not a prognosticator about where we are in terms of whether this is a bubble or not. I can tell you, in our world, the disputes world, litigation, we're seeing a lot of AI-related disputes. There's no question.
And is that around primarily today? I can imagine the trajectory is like right now it's a lot around IP, right? We saw case against Anthropic around their usage of, I forget.
Reddit.
There's Reddit getting litigated, but then the books where
they just did a huge settlement.
It was a big settlement. And so right now it feels like we could be in the era of like litigating around IP and what even is IP in the world of generative AI.
But no one's losing money.
But then it feels like the next wave could be around just rehashing and litigating. It's going to be a lot of lawyers looking over, this announcement that went out. It's like, yes, in the fine print it said that it wasn't an actual deal yet. It was just a kind of a general sentiment from the two companies. Where do you think? Do you think we're at all close to having some like precedent around AI and IP, or is this going to take years?
I mean, AI is throwing up so many novel legal issues. I mean, IP for sure. Everybody's heard about the cases that have been brought relating to music, literary works, visual works, using copyrighted materials to train large language models, and whether that's copyright infringement or what's called fair use. So we have dozens of those cases. We finally have a couple of decisions now out of the federal court in San Francisco, where the judges in those two cases, one case involving Meta, another case involving Anthropic, decided that it was fair use, that it was not copyright infringement to use copyrighted materials to train large language models, although both decisions were kind of qualified, and there were some unique facts in both cases. But yeah, we're starting to have those decisions on various issues, but there's so many things. All this money is going into large language models and AI, and there's
you think a lot of founders are just running the calculus of, I know that I'm going to have to eventually pay out something for what I'm doing, but I'm just going to run with it because I'll be able to eat the cost later, and if I wait, then my competitors will.
I don't know, losing one of these cases, the copyright cases, there's so much involved, the price tag could be very, very big.
Yeah.
So I don't know that people are sitting back saying,
but
it's just the cost of doing business.
Yeah, but at the same time, if your competitor is like willing to take the risk and they can ramp their market cap up into the hundreds of billions, they know that, and the alternative is, being safer around IP, and then you just lose the race, then you're a zero anyways. So I think it feels like a lot of people are willing to just roll the dice and say, we'll figure it out later.
Well, Apple in its early years had a reputation for not being very careful with its IP. They launched the iPhone knowing they did not own the name iPhone.
Oh, yeah.
It was owned by, I think, Oracle.
Oracle
or Cisco.
Owned it. Yeah, Cisco.
Oracle.
Cisco, I think.
And so as soon as they launched it, there was a lawsuit filed.
Yep.
Cisco versus Apple, and it was immediately settled. I've never heard what it settled for. But, that was Steve Jobs, driving ahead and kind of doing what you're saying. I think they've gotten a lot more careful. But there's just a host of issues. Like, you have all this money going into AI and AI inventions. How are you going to protect it?
Yeah.
You cannot patent an algorithm. You cannot patent a mathematical application. These come under the rubric of general ideas.
Yeah, and again,
laws of nature.
Yeah,
So,
and then in the talent wars are a whole other thing. I'm curious if what your kind of view on, over the summer we saw all the labs kind of poaching, pulling talent from different places, and people realizing that in this person's brain is like potentially 100 million.
You think they're not being hired for what is in their brain?
They know.
Yep.
Yeah.
Of course they are.
And
that's an example of what I was referring to earlier, where the major players are very reluctant to sue each other. I'm kind of surprised there hasn't been more litigation over this poaching, but I think it's this phenomenon that...
but our view is that they were very much like acqui-hires, just unauthorized acqui-hires, where it's like this team knows how to do something really well that they've learned through spending tens of millions or hundreds of millions or sometimes even billions of dollars, and we want what they know how to do. We want the process that's in their head, basically.
Yeah.
There's no doubt. I mean, some of what you're referring to is trade secrets.
Yeah.
Trade secret law, which is another area of intellectual property, and that's an awful lot in the AI world, what we're talking about, mathematical applications, algorithms, and the like, that can't be patented. They can be trade secrets, and they can be protected as trade secrets. And if somebody has access to those and goes to work for a competitor, it's not lawful for them to be using that information when they go to work for the competitor. But then proving that actual use, is another thing altogether.
How often would an issue pop up and you have multiple? Let's say it's Mag 7 on Mag 7, and you're getting calls and texts from both of them racing to work with you guys. And then have you ever had to make a call in the moment?
In that world, we never encounter that because we always and forever have been adverse to Apple, Meta, Amazon, and Microsoft.
Okay.
We've always represented Google, NVIDIA, Qualcomm, Salesforce, and some others.
Sure.
In our world, it seems like you come to a fork in the road and you decide we're going to go this way, and you never come back because people know you're the firm that will be adverse to Apple. It's like being the firm in Seattle that'll be adverse to Boeing.
Yeah.
I mean, that's kind of a job in itself.
Yeah, that makes sense.
What about...
I mean, it does happen in other areas of practice, like in private equity. I mean, we had a situation just within the last couple of days where two global private equity firms who were opposite each other with respect to a particular transaction both of us called us,
Yeah.
and we accepted the engagement from the one that called us first.
Okay.
So that does happen.
There you go.
Is being litigation only an advantage in being able to create this patchwork of clients that you don't have conflicts because you're also already doing their contracts or anything, so you can be a little bit more?
I think as a litigation-only firm, we have fewer conflicts.
Yeah.
So for us, the world is divided into companies and individuals we represent and those we don't.
Mm-hmm.
And sometimes a company or an individual moves from one category to the other.
Yeah.
But we have very few sort of lasting conflicts vis-a-vis the business world in principle.
Mm-hmm.
Where deal lawyers, there might be some industries that they know, well, we just can't be on this other side of this issue or represent a competitor or the like, because it's a little bit different in the deal world.
Where's your firm getting leverage from AI today?
We're using it. We're using it a lot. We're using it to, not only to manage documents, the things that are produced in discovery, because we've been able to do that for a long time, but to be. If you can imagine, we tried a case in Delaware a few months ago, and we had loaded into the database all the deposition testimony, all the documents, and the trial testimony as the trial's going down, and as somebody's on the stand. I mean, you can imagine, you can query this database. What is the best evidence that so-and-so just lied about that?
Yeah.
Yeah.
In
real time.
Yeah, and it'll, you press a button, and it'll give you a list of things in rank order.
Yeah, yeah.
Now, if you
And
had
before, back in the day, 90s, early 2000s, 2010s, you had to be
Go back to the filing cabinet.
Yeah, or just you had to be
you're relying on your
witty.
memory
Yeah.
and what you know and what you know about the case, and still that's the most important thing, I think. And mostly it's kind of a backstop. It's a check, things you would have thought of anyway. But it'll also come up with things that you wouldn't have thought of, or maybe you would have thought of if you just had more time.
Mm-hmm. What are your thoughts on resolving co-founder conflicts? There's been a number of really high-profile cases around a group of people came together, started a company. The company grows and grows and grows. Some people leave, and then there's
Winklevoss twins.
That was one example.
We settled that case.
Yeah,
and we didn't file the case. We were brought in to settle it.
Sure.
Snap.
Yeah.
There was a third guy in the garage.
Yes.
Who got kicked out.
Yes.
And he brought a claim.
Are there any common pitfalls that you see on the incorporation documents or the safe note or specific?
People start working on these projects, all the time.
Yeah.
And they're not thinking about this might become super valuable someday.
Of course. Yeah.
Maybe they're more sensitive now in the tech world, and so
it's
they
easier than ever to create. You can create a C corp in a few clicks. You can see.
Yeah,
exactly.
and they don't think to lay out. Okay, who owns what? What's my share? What's your share? We're friends, right?
Yeah.
So they don't think to document it.
Yeah.
And it's not till later that, and suddenly it's super valuable.
Yeah.
And they're getting all these views and followers, and they realize, wow, this is super. Now remember, this is 1/3, 1/3, 1/3, right?
Yeah.
No. That was not my understanding.
Yeah. How much in a case like this is it worth pursuing a settlement, taking it to trial? Like, what are the key decision points where you realize, okay, this is going to trial?
I mean, usually, so there's a stage called summary judgment, where a party can go to the court and basically say, look, on the undisputed evidence that's been developed in the course of discovery, I'm entitled to judgment as a matter of law.
Sure.
It's basically you're arguing to the court, no reasonable juror could find for the other side. They could only find for me.
Yeah.
And there has to be no disputed evidence. And the judge has to find, okay, on the law, and yes, the evidence is undisputed, you win. If and a lot of cases are dismissed at that level. If it gets past that, then there's the prospect this case is going to go to trial. There's nothing really going to stop it because that's kind of the last court off-ramp. A lot of cases are resolved in mediation. In any significant case these days, the courts will expect you to go through a mediation. That is to say, engage a neutral professional mediator, spend some time with the mediator, and see if you can resolve the case. And that happens, sometimes it happens right at the beginning of the case, or even where there's a dispute and no case has been filed, you get a mediator together. Sometimes it happens on the eve of trial, but a lot of times it happens in the course of a mediation. So, if it's gone past summary judgment, if you've gone through a mediation and that hasn't been successful, then that looks like a case that may go to trial.
And is that a function of total settlement? How much is at stake relative to the legal bills? Am I more likely to settle a case if it's $1 million at stake, but $500,000 in legal bills that I'm looking at, versus there's $1 billion at stake?
I would certainly think so. If
Right.
the legal bills are
Yeah.
more than what you would get out of winning the case.
Sure.
Sometimes
bail.
there's other things, at stake,
Sure.
whether ego or
Reputation.
whatever, or
Yeah.
reputation. But it's usually a calculus. I think most clients, it's pretty much an economic
Yeah.
calculus. What are my chances of prevailing at trial? What do I get what does prevailing mean? What will I get if I prevail? And obviously, what's the cost to get me there, including primarily attorney's fees?
Do
you think that AI will speed up cases, or is there some element to litigation that just because maybe one side realizes the longer this goes on, the better for me, I'm just going to drag it out? Like, will it actually, even though a lawyer could now do 2 weeks of work in an hour, maybe if they're properly using some of these AI tools, it might still just take the full, however many 2 weeks in order to
because
file.
the other side's going to be using AI, right?
Yeah, look, I mean, cases settle when parties realize the strengths and weaknesses of their case and the strengths and weaknesses of the other party's case. And they assess that. Cards in the discovery process, everybody's cards are basically put on the table.
Yeah.
And you have a basis then to make a judgment about, am I going to win? What does winning mean? What am I likely to get in damages? I think AI will accelerate that process. There'll be more disclosure and more ability to handicap the potential outcome sooner. So I do think there's a potential for resolving cases sooner. However, I think AI is going to result in much more litigation.
More cases. Yeah.
More cases. Why? There are already early stage companies out there who are putting cases together. They have put into databases all records about permits, licenses, advertising, what parties claim is in their product, what they say their product can do, all this information, and then information about what is actually in the real world, what's the experience there. They'll put that together, and they will serve up to lawyers. You can subscribe to these services, and they'll come to you to say, I've got these great class action lawsuits for you. And so they're finding cases. So I think there will be more cases, but I think there's a potential they'll be resolved sooner.
Do you think the legal profession is a mentorship business? Do you, like when you bring on, do you see young lawyers needing to find a mentor to establish a full career? Is that how you think about it, or? I
really think the best way to learn is working with more experienced people. That was certainly true in my case, whether you call them mentors or just senior people in the firm who you work with. And go to court with and see how they examine witnesses and the like. So I do think that's really important in terms of learning what it means to practice law.
What advice are you giving to young lawyers today that want to be where you are in 30 years or so?
Well, as I said earlier, I tell people, this is practicing law, litigating high-value cases at the highest level there's no shortcuts. So you have to be prepared to sacrifice and work super hard. It's an hours commitment. There really are no shortcuts.
Is it thrilling, though? Do you love it?
I do love it. I do love it. And
is the case more thrilling, or is it who you're working on behalf of? Is it the partnership between you and the client? Because I can imagine
the partnership with the client can be very, very satisfying. Because
this is a team sport, right?
Exactly. It's definitely a team sport. The team within the firm, the team with the client. What I love most about it is we're constantly learning. We have to be able to cross-examine experts, whether it's on biotech, steel manufacture, AI, I mean, you name it. We have to get to the point where there's an expert on the stand, somebody maybe has a PhD in something, and we're going to cross-examine them. We have to learn. That's what I love about my job.
And
we're always learning something new.
Yeah, an expert can make something you sound really silly. What do you mean by that? Like, I don't understand what you're even asking. And then they could just be,
You sound like an evasive expert.
Yeah, exactly.
That's not going to be great for your credibility.
There you go.
What about how the media characterizes law? Is there a book or movie that stands out to you as kind of telling the story the correct way that resonates with you, that's something that you don't feel like it's a mischaracterization of how you work?
You know, there are a number of good books about trial lawyers, and perhaps my favorite was written by a trial lawyer who recently passed away, Jerry Spence. I don't know if that's a name you know. Famous trial lawyer from Wyoming. He did the Karen Silkwood case, that uranium case. She claimed that she was injured by exposure to radiation. He represented Imelda Marcos in a trial in New York City. I mean, but he was always kind of this Wyoming buckskin-clad country lawyer.
A character.
And he wrote a book called Gunning for Justice.
Yeah.
That was about his own life.
Okay.
And it's a very, very moving book. That's one that I really enjoy.
I will have to pick it up. Well, thank you so much for coming by
Thank you.
and doing this interview.
Thank
This
you,
was
John.
fantastic.
Enjoyed it very much.
Thank you so
Jordi,
much.
Thank you very much.
Come back on
Thank you.
anytime.
Yeah, you're welcome anytime.
What a legend.